afternoon, everyone. Good afternoon, distinguished speakers and the audience. We welcome you all to the second week of the Udo and Belo-Osagie's Regulators Masterclass. A little bit about our firm. We're a leading multi-specialization firm founded in 1983 with offices in Nigeria's key cities and an affiliate in Ghana. We're also now an alliance firm within the Bowman's network. For several years, we have provided investigations, compliance, and ethics advisory support to our clients in various sectors of the Nigerian economy, and have been doing so, supported our clients with several capacity building initiatives such as this. We conceived this two-part Regulators Masterclass as part of our EYES September series, which was a series of trainings that we offered to the public in the month of September on various compliance issues ranging from crisis management to investigations to corporate governance, done rates, and data protection. And off the back of that, we decided that we were going to have a bespoke masterclass for regulators so that we can focus on investigative efforts and other issues such as strategies for driving compliance. These two-part masterclass commenced last week, and we had our very interesting session. And I say interesting because of the range of questions that we received from the audience. That session was facilitated also by Mr. Bamidele Sonya, as well as a gentleman from Kroll, which is a leading risk advisory firm. This week's session, on the other hand, will be facilitated by one of our colleagues, Olukayode Dada, as well as Mr. Sonya as well. And today we will be discussing the topic titled Strategies for Driving Compliance, where we will seek to cover issues relating to how regulators can drive compliance within their regulated sectors, as well as within the sectors that they regulate, so that the focus isn't just on how to impose penalties on their regulated entities, but how to encourage them to comply with the various laws and regulations that apply within those respective sectors. We're very excited about this, especially with the level of participation that we received last week, and what we look to, and we also look to having the same level of participation at today's session as well. Without further ado, I will hand over now to my partner, Lolade Oshasami, who will introduce the speakers before they go into their presentations, and who will also moderate the question and answer session at the end of the presentations. Lolade, over to you.
Thank you very much, Adeola. We'd like to first of all welcome our participants, hoping that you were here with us last week. I have the pleasure this morning of introducing again our expert from the World Bank, Mr. Bamidele Sonya, who today will be speaking to us on how to create an ethics and compliance culture. Mr. Bamidele Sonya is a Nigerian and UK qualified attorney. He is currently Chief Counsel responsible for ethics at the International Finance Corporation, a member of the World Bank Group in Washington, D.C. He joined the World Bank in 2010, serving as investigator, senior investigator, investigations manager, and most recently as EBC's Chief Counsel responsible for ethics in the Africa region of the World Bank. Bami has over 25 years experience in legal practice, investigation, and ethics. Prior to joining the World Bank Group, he worked as a managing associate in the London office of the international law firm Linklaters LLP. This afternoon, Bami's message to us is compliance is everything. Our second speaker is our homegrown expert, compliance and ethics expert, Oluka Dada. Oluka is a managing associate in the firm's dispute resolution, compliance and investigations and IP teams. His core specializations are commercial litigation, white-collar crimes, ethics and compliance, anti-corruption, anti-money laundering, combating terrorist financing, AML, CFT laws, cybersecurity and intellectual property. Luca Ade has extensive experience in commercial litigation, IP, and conducting fraud and anti-corruption and other ethics-related internal investigations. He has spoken at global conferences, including the 35th International Conference on the Foreign Corrupt Practices Act in Maryland, USA, and at the National Bar Association's Corporate Council Conference in Orlando, Florida. He is a contributor to the Lex Mundi Global Anti-Corruption Compliance Guide, and his work has been recognized by the Legal 500. This afternoon, Oluka Ade will be speaking to us on the need for charity to begin at home, where compliance is concerned. Without further ado, I hand over to Bami, who has a presentation this afternoon. Bami.
Okay. Thank you very much, Lolade and Diola as well. Good afternoon, everyone. It's a pleasure to meet you guys, and hopefully you're keeping well with this new normal. The lockdown, which is quite global. I'm very excited to have this conversation. I see this more as a conversation, and you will probably see why I like to have this kind of conversations. So let me add to the background that Lolade provided. I'm an international civil servant, so I'm in a very similar situation to most of you. I'm going to make a number of controversial statements because I enjoy making controversial statements. But before I do that, to give you the context, so the World Bank, as you know, is a multilateral development organization. So the staff of the World Bank are basically international civil servants and subject to regulations and policies and laws, internal laws that make up the World Bank. Last week, I did say that the World Bank is a country, it's a state. We make our own rules. We have privileges and immunities, but we mimic the rules that obtains in national states. So it's an international person by virtue of international law. But the lessons here, the message that we'll be sharing today applies equally to you as regulators and public servants. So it's not devoid of relevance. Let me just put it that way. So if we go to the slide, the first page of, not the cover page, if we can move on to the first slide. What is a culture of compliance, right? Now, let me make two controversial statements, first of all. The first one is, you don't control what you do. Not all what you do, you'll be surprised. You think you have the ability to control all your actions, but actually it is proven. Some of you may have read the book Thinking Fast and Slow by Daniel Kahneman. Some of you may also be aware of the research that has been done by behavioral scientists or behavioral economics. Daniel wrote Thinking Fast and Slow, and that's a pioneer book that underscores what I just said, that you may not actually be in total control of your action. You'll see what I mean by that. But Daniel is a renowned behavioral scientist and won the 2002 Nobel Prize in Economic Sciences, right? And now, what does this say? This also says that culture is very, very important. It means that you can shape culture, and this is why I'm bringing out this. Apart from Daniel Kahneman, there's been a number of studies as well which confirms what Daniel Kahneman wrote in his book, which is that the stimuli around you determines how you behave, how you react, even though you think you are in control. You may also have heard the statement, culture eats strategy for breakfast. And for me, culture is the driving force of compliance. Compliance, and that's where you had something like, value-based culture, that we're not legalistic. And this is why it's very important in the area of compliance. And therefore, as a regulator, you need to be mindful of the fact that, as Deola said, the natural reaction is to think about enforcement. Whereas what you should be thinking about, even before the regulations are made, what are the habits, what are the cultural norms in that industry in order to make a buy-in, and make voluntary compliance essential. So this is very, very important. And that's why I start with the culture. It is about shaping a positive attitude towards ethical-based behavior. It is a way to drive ethical choices among common ethical dilemmas and challenges to an organization. The other thing I wanted to make on this point is what I consider to be authentic integrity. Now, what does that mean? It means that an organization voluntarily, makes those right choices, doing the right thing in terms of their legal obligation, regulatory obligation. So let's move on to the next slide. So why is this important? Why is this culture of compliance important? I think we have seen it all. Recently we saw what happened with VW and some of the other car companies in Germany with the emissions, the diesel emissions scandal. With Boeing, this is very, very real. Failure of compliance in Boeing, has led to not just deaths of their customers, but complete loss of confidence and trust in the ability of the regulator, FIA, to do its job. They were simply found to be in bed with the executive of Boeing, and this led to the fault in the MAX Airlines, which, as you know, led to several deaths of their customers. The other thing about culture of why it's important is sustainability. The sustainability of an institution depends on the culture of compliance. And this also connects with the trust that stakeholders have. Now, stakeholders before now used to be just your staff, the entities you regulate, but no, not anymore. Stakeholders extend to the society at large. Using the example of the World Bank, when we conduct our business, right, we're not just mindful of our clients, but also the society. You may have heard about the popular JAM case, and this is when I talk about sustainability. I mentioned to you before that we had privileges and immunities, but one mistake can bring the whole organization crashing down, right? And the JAM case was a case that involved IFC directly. IFC invested in an operation in India, electricity, expansion of electricity in a rural place in India. As a result of our investment in the private companies who were doing business there, it affected and impacted negatively fishermen in that locality, right? They complained to our CAO. So we have an ombuds office where people negatively impacted may bring concerns. Now, that concern was not dealt with. And this group of fishermen, they were linked with an NGO in the US. And when the NGOs get involved, it becomes a big issue. And they challenged IFC at the district court in DC. We pleaded our privileges and immunities and say we're above the law, where we cannot be held to account. But on appeal to the Court of Appeal in DC, Eastern District, the Court of Appeal recently, just about 9 months ago, held that because we are engaged in business, because IFC had engaged in business, In other words, they limited the scope of our mandate under our articles of agreement and said because we are engaged in business, a person who is affected by what we did, even though we did it through an intermediary, the private entities, we are liable to be brought before the court. The case has not been decided yet on its merit, but it goes to what I mean by sustainability. That if you are not compliant, the risk there is that your business model might fail. So this is very important. And this also speaks to our reputation and our standing in terms of a culture of compliance. Now, as regulators look at this internally in terms of their operations, they also be mindful that these are the things they need to consider with regards to the entities they regulate. The other thing I want to mention on this point, some of you may be already familiar with the US federal sentencing guideline. Now, this speaks to how regulators drive compliance. The sentencing guideline is a blueprint. So when a regulator in the US is dealing with non-compliance, one of the first things they consider is what structure does this organization have in terms of its compliance regime? It's very, very important. And this has actually, it has been a catalyst for the developing field of compliance. Because what are they looking for? They're looking for the fact that you have an education and training program, you have the requisite policies, you have the tone at the top in the form of the board, responsibility and taking ownership for compliance. This is what led to it. The other thing that you'll be surprised, the code of ethics that we talk about these days, the code of conduct, how did it come about? This also came about because of the anti-corruption laws in the US, which basically said that public companies needed to have a set of values, not just rules, not just the law, but a set of values that is a yardstick for measuring compliance and behavioral expectations within the organization. So I'm going to move on to the next slide here. I'm sure that you already have questions that you might want to ask, but we'll do that at the end of the presentations. So, but let's move on to the next slide. Thank you. So these are the critical components. I'm sure that you're familiar with, if not all, some of these components of a culture of compliance. One of these is, I get a lot of questions, why do you have to have a chief compliance officer? It's not just why you need to have a chief compliance officer. It's also the position of the chief compliance officer within the organization. Not that I'm pushing for myself, but it has to be a senior position, right? It has to have credibility. It has to have gravitas, right? So it's not just important to have compliance officers. An organization that is serious about compliance needs to put its money where its mouth lies, which means that in terms of the ranking, the chief compliance officer, for example, in my organization, the chief compliance officer reports directly to the president. So no matter what their level is, they have a direct dotted line to the president of the organization. Another important factor is that they have a direct line to the board. And every year, I think we did that just last month, at the end of the fiscal year, we make a presentation not just to the HR committee, HR and ethics committee of the board, but also the general board meeting. We make a presentation, and they actually make demands. In fact, as a result of the direction of the board, the World Bank Ethics Office have decentralized, and we've increased capacity so that we're now not just in Washington, D.C. I was in Nairobi before, but in addition to Nairobi, we are opening new offices in South Africa, in Senegal, and in Bulgaria, where we are going to have full-fledged office so that we are accessible and available to our staff because we are decentralized. We're currently in about 120, we have 100 offices in 120 countries. So we are going out there. This underscores the importance of ethics and compliance. And so that's when I say chief compliance officer, I mean that compliance officers are highly regarded and allowed to have access, because you are going to make some calls that are going to be controversial, right? And you have to be confident that you have access to the highest authority within the organization. And so as regulator, I'll be thinking when I look at an organization in terms of the risk profile, where is the position of the chief compliance officer? Who does he report to? What is the budget for the chief compliance office? I'll be mindful of that. Recognition and rewards. You have to align recognition and reward. In other words, what is the incentive for somebody to comply within that organization? What is the incentive? You have to incentivize recognition and recognize people, not just financial reward, but the value of that organization must be geared towards a compliance culture, and that is so important. What else? Code of ethics. This is very, very important, and I can share with you our own experience at the World Bank. Recently, we have revamped. We've had a code of ethics. We called it the code of conduct. We've had it for well over, before I even joined the World Bank in 2010. But recently we embarked, and I think it's best practice in crafting a code of ethics, which was basically crowdsourcing. It was a crowdsourcing effort, bottom-up effort to craft the code of ethics. It involved setting up a working group and drawing up views, inputs from all our country offices, the over 100 country offices. We got staff to input it, and that's why I said we crowdsourced that, and that led to the development of the code of ethics, which is aspirational, but at the same time is a mechanism for good conduct and enforcement. Now we're in the process of socializing that code. We have a lot of ways in which we are socializing it, including e-learning. We're doing, even in a virtual space, we're doing a lot of training and ensuring that people are familiar. What does it speak to? How does it affect you? How does it apply to you in your day-to-day activities? And that's very, very essential, because sometimes we assume people know, right? But some of these rules may not be self-intuitive, right? And therefore, there's a need to spread the message. What is the organization about? We have a laudable mission at the World Bank. Our mission is to eradicate extreme poverty and facilitate shared prosperity. Middle-income countries, help them to make sure they don't fall behind, right? These are fantastic objectives, but then how do you action it? How do you actualize that mission? And this is what speaks to a concerted effort towards socializing the code. Investigation and discipline. Investigations and discipline, this is basically enforcement. This is basically enforcement. You need to have the carrot and the stick, right? But you know that investigations and discipline or enforcement alone will not suffice. Okay, let's move on to the next slide. Thank you. This is very significant. Tone at the top. If somebody asks me, what is the singular factor for efficient, effective compliance program, this is what I'm going to pick. I think last week, somebody may have also mentioned the same, that in terms of the tone at the top, this is the most significant of the factors that make for a successful compliance program. It is the foundation on which everything is built. There's a saying, the tone at the top leads to the mood in the middle and trickles down to create the buzz at the bottom. But it is true, and a number of studies have been done that indicate that where the management, the senior management and the board take ownership for the ethics and compliance agenda, it is difficult for it not to impact the whole organization. And when I say tone at the top, it's not just talking about it, it's also doing it, walking the talk, doing the ethics work. It's very, very essential. And, we need an organization where the management, senior management and board are supported by the ethics or the chief compliance officer to make sure there is open and regular communication in terms of the senior leaders. And for regulators, there's so many examples to talk about. The last week I was talking about the chief executive of Barclays, who was found to have tried to identify a whistleblower by asking a security chief to make sure they find out who wrote a letter complaining that he influenced inappropriately. The chief executive influenced the recruitment of a senior official into Barclays. And we know how the regulator in New York came down heavily on him, fining Barclays a couple of millions of dollars. And the regulator in the UK did as much. And we also talked about the owner of Los Angeles Clippers, and how the NBA regulator came down heavily on him. In fact, he stripped him of the ownership. His actions stripped him of the ownership of the LA Clippers, a basketball club in Los Angeles. So these are some of the failings that we see at the top, but it's important to also recognize the importance of this and the leadership that comes with making ethics effective through the tone at the top. Yeah. So I'll move on to the next slide. Organizational justice drives culture. This is also linked to culture. There has to be hotlines, opportunities for people to bring concerns to an organization. Now, this applies equally to the regulators as well, internally. So it's not just externally focused. An organization that is being regulated has to have a mechanism, a protocol, a procedure to ensure there is justice, right? And similarly, the regulator needs to have these avenues for people who deal with them, the entities who deal with them, to be able to bring concerns forward as well. And this is very, very important. One thing that is also very powerful when you come to organizational justice in driving compliance is about transparency. It's about transparency. It's very, very important. Some of the things we do in our organization to drive this is that we publish disciplinary actions and remediation, even though names are not mentioned. So we don't breach privacy or confidentiality of the process. We publish every quarter. When it comes to our internal investigations, we do a summary of what the case is about. And also we put down the grade level of the person involved and the disciplinary measures imposed. In terms of our external investigations, we do also put that on our intranet, which is, what are the issues, which organizations have been debarred, what they did and all that. Now, the truth of this is that it ensures that there's trust within the system because people can see what you have done. One of the challenges, if you appreciate, is trust in the organization and the effectiveness of the compliance program. And to build that trust, you need to put out information to be the basis of why people will trust the regulator or why people will trust an organization. And that's why we publish this. Another important element of organizational trust is about speaking up culture, right? We have that. A lot of organizations have that, the challenges of speaking up culture. And fundamentally, it's because people are afraid of retaliation or that nothing will be done. Global ethics survey, since I've been in ethics field, this has been a perennial issue. There is a fear, a real fear of people reporting concerns. And at the World Bank Group, we recognize this, and this fiscal year, we are in the process right now of adopting benchmarking first and trying to adopt best practices in whistleblowing and anti-retaliation, in whistleblowing and anti-retaliation protocol. We currently have consultants working on this for us, carrying out benchmarking, not just of public development organizations, but public institutions and the private sector, in order to try and gather what are the best practices, what does the science say there now, and use that to look at our policy. This kind of this kind of effort should be something that regulators need to do regularly as well. What are our practices that we can work on in terms of what are the best science out there? What are the best practices out there to bring to bear, not just in enforcement, but also in making policies, and in our operations. What are the best practices? What are other people doing? And this is what we do regularly. Recently, as part of this ensuring a value-based culture, we looked at issues surrounding harassment and sexual harassment. I spoke about that last week, and looking at how we can, make the environment. You guys probably also saw I think it was a few years ago, the Me Too movement. This was not just in the private sector, but also in development organization. And it impacted our approach to addressing those problems. We set up a working group to try and see what the best practices are. And we came out with, a few cutting edge, if I may say so, cutting edge solution, including the creation of an office that solely focus on those issues. So, and another thing that I wanted to mention also is annual reporting, focused on organizational justice and disciplinary measure. This is also part of transparency in terms of what we do when allegations are brought to our attention. So if we move on to the next slide, please. So communication, training and education. This is very, very essential. Regulators should not assume, you should not assume that the regulated entities understand the policy behind or the basis behind some of these regulations. And so when you make regulations and you want to enforce it, don't just assume that people know about it or they know what is expected of them. And this extends to our policy. We have the code of ethics, and we're doing a lot of information campaign to try and make people understand the basis of why this code of ethics exists. What does it speak to? What does it speak to? In terms of our anti-corruption effort, we place a lot of emphasis on prevention of corruption. Some of you may have attended some of our procurement. Our procurement processes, we know it's not self-intuitive, right? So we organize for our stakeholders, people who contract with the World Bank, who do business with us. We make a concerted effort to do a lot of training for external parties. And this is something that regulators should also bear in mind. Don't just assume that people understand how to comply. In my time in Nairobi, I dealt with and I worked with the ethics. Some of you may know this. The equivalent of Nigeria's EFCC is called the Ethics and Anti-Corruption Commission, which is based in Kenya. And I worked with them in developing their curriculum, their prevention, anti-corruption prevention training. Some of the practices that we have at the World Bank, which will be beneficial to them, we included it in the training. And in fact, we had joint event in order to share best practices. So this is very, very important for for compliance, that there is a need for constant training, evaluation of the training to see how relevant it is to the situation, and monitoring as well. The lessons from the monitoring effort that you do should be fed back into the training system, and also communication in order to spread the message in various formats, and to reinforce the message of compliance. So I'll move on to the next slide. I know I have 4 minutes, but I think I'm doing well for time. So measuring effectiveness, right? So you don't want to be in a bubble, right? You don't just want to be in a bubble. We have a policy, we have enforcement, and we just hope for the best. You want to see whether you're making a difference. Does that compliance program make a difference? Is it changing behavior? Remember, I spoke about culture, right? So you need to have a measurement. How impactful has your culture or the culture of the entity been as a result of this compliance program that you have? And this will mean quantitative and qualitative data in order to feed back into the policy. The policy might need updating. The policy might not work because it's not effective. You have to look at the outcomes. What are the outcomes? And when I talk about outcomes, I don't mean enforcement, because enforcement, what you want is voluntary compliance, right? It's not about, what's the point? You don't want it to be all about enforcement. It's about voluntary compliance. How do you get there, right? So you need to measure the effectiveness of the program to understand whether you need to make adjustment. You need to think about things differently. You need to simplify the regime of regulation. So this is it's not a tick the box exercise. It needs to be feedback into the policy making. It needs to be take back, used to see how we can improve the enforcement and also the compliance. So it's very, very important. We are always, at the World Bank and IFC, we are always doing surveys. We want to see whether the policy objectives have been met. So we are always checking it out. In our, even our training, we want to make sure that the training actually works. And so this is why I talk about behavioral sciences and behavioral economics. It's not just a psychedelic exercise. It actually works. And a number of studies, I can tell you how many studies have been done in Ivy League and in Europe, that speaks to that you can actually make a dent by focusing on culture. And you can measure it, it's measurable. And so this is very, very, very important in terms of getting feedback. How well are we doing? And how well are we doing for time? I have 1 more minute, but if we can move on to some of the penalties that we have now. This is basically in terms of the World Bank Group. We have a sanctions process, which is not just limited to the World Bank. We led the development of this sanctions regime, which now includes most of the multilateral banks, development banks. And so it means that if a corporation goes through our process, when we debar them, there's also the opportunity for cross-debarment, in which case the organization will not be able to do business with all the multilateral development banks that have signed up to our sanctions regime. And our sanctions regime is basically copied, if I may use the word copied by other development banks. All the development banks have basically come to us and said, look, just give us what you have done and we'll just put it in our organization. But it's based on fairness and justice. Like I was saying last week, we have a legal regime within the World Bank. So this is not taken lightly. An organization can challenge before our sanctions board, penalties for non-compliance. So I'll stop here now. It's 9:41. So thank you for listening. Thank you for your time.
Thank you, Bami. You actually have 9 minutes surplus, but I was also coveting your extra minutes because I'm sure we're going to need them down the line somewhere. But thank you for your presentation.
Thank you.
I listened with keen interest, even as I tried to decipher the context of the presentation, seeing as we are addressing regulators, and just wanting to clarify, are you advocating for regulators to set the tone at the top by ensuring that the regulatory agency itself has a culture of ethics and compliance within the organization as a way of driving compliance among the targeted entities? I just would like you to clarify that point before I move on to Olukayode, because we haven't reached the Q&A sessions, but I just needed that understanding so we can move on.
Thank you very much, Lolade. I think you hit the nail on the head, basically, that the regulators have to be an example for the entities they regulate. So as you know, and I go back to the US in terms of example, that the regulators themselves are being looked at by those entities. To what extent are they practicing what they preach? And so they also need to set the tone. I think it's very fundamental. I said tone at the top is probably the most important element for ethics and compliance. And regulators must be above boards. And they must be seen to, not just above board, but be seen to be above board. Because this is essential. They set I talk about authentic, the language that I like to use, radical candor, authentic integrity. It's about leadership, and they have to lead from the front. It's very essential.
Thank you so very much, Bami. I now move on to Olukayode to give us his own presentation. Charity begins at home is Olukayode's message to our participants today. Kayode, you have the floor.
Good afternoon. You are welcome to this session. Mrs. Osabi was right. When I was preparing this, when I prepared this slide, I had actually titled it, Charity Begins at Home, Effective Ethics and Compliance Guide for Regulators. However, because I am a Yoruba man and I'm a bit sensitive, so I decided to, to take off the Charity Begins at Home part so that we can have effective discussion without offending anybody. All right, so let's move on. Let's get into it. Now, the scope of the presentation is we just look at three things. Why ethics and compliance? Now, what are the elements of effective ethics and compliance programs? Mr. Bamidele had touched on this, so I will not really dwell so much on what constitutes elements of effective ethics and compliance programs. Now, we then move on to tools to ensure compliance by regulated entities. And between the second subtopic and the third subtopic, they are tied, because if regulators have internal effective ethics and compliance programs, that is when they can ensure that the regulated entities also maintain the same standards. And this was where, that's the point where I introduced Charity Begins at Home. Then we then move to the way forward. How do the regulators move forward? So let's get into it. Now, I did not overemphasize the importance of ethics and compliance. You know, an effective ethics and compliance helps a regulator or any organization, be it private or public, to operate within the ambit of the law. And then it ensures that the organization itself comply with its own ethical principles that are essential for its identity and operations. Now, if an organization lacks effective E&C program, ethics and compliance program, that is the recipe for scandals that may cause long-lasting damage to the reputation of that organization. And really, in the case of a company, it may lead to its death. I'm sure that we can all remember the snake ate money scandal that happened at the JAMB office. You know, so the scandals occasioned by lack of ethics are not only limited to corporate companies. They also exist in regulators. And we can point to so many, but we don't have time to do that today. Now, an organization is only as good as its reputation. You know, for companies, for instance, having an effective ethics and compliance program, and pardon me when I say E&C program, that means ethics and compliance program. Now, having an effective E&C program enhances profitability. Now, for regulators, you know, ordinary citizens, civil society, and business leaders now have expectations of government agencies. They expect government agencies to deliver higher standards of ethics and integrity. So typically, and my colleague Adela can confirm this, we get international companies asking us questions like, how effective is enforcement of laws in your country? You know, questions like such questions and similar questions. So they want to know whether even the regulators that regulate companies in Nigeria maintain effective ethics and compliance programs. Because it is only when regulators maintain internal and effective ethics and compliance program, that is only when the regulator can be on the right pedestal to encourage the regulated entities to do the same. Now, I do not need to repeat what Mr. Sawyer said. Mr. Sawyer said that it is essential that regulators, companies have written internal code of conduct and policies that apply to everyone, from staff in the lowest cadre to directors and DGs. Because the reason for that is that the tone at the top is essential for the success of every ethics and compliance program. So let's move on to the next slide. Now, I have here elements of effective ethics and compliance program. There are 7 of them, really. And Mr. Bamidele mentioned the US federal sentencing guidelines. Now, these elements of effective ethics and compliance program that came from that federal sentencing guidelines. And these elements have now become acceptable all over the world as the minimum elements that any effective ethics and compliance program must have. Now, what the US federal sentencing guidelines does is that, in fact, so when an organization, not an individual now, a company is charged, and the federal judge wants to determine what sentence after being convicted, what sentence should be given to the directors or the company itself. Now, one of the things that the judge or the court is required to consider is the effectiveness of the ethics and compliance program of that convicted organization. So what that does is that that helps organizations to say, to avoid a serious liability. So for instance, maybe just a director, a finance director decides to commit fraud, and that fraud binds the company. And the director as well as the company are charged. And so the company may be able to avoid liability by saying, we have an effective E&C program that was so effective to prevent this kind of fraud committed by this director. So this is not the norm for us. This is just an aberration. So that helps the organization to avoid what would have been a disastrous penalty. Now, for regulators as yourselves, it is also very key to have an effective ethics and compliance program. Let me give you an example. If every manager can dip hands into the purse of an agency without taking approval, if every supervisor can sexually harass a junior employee, a junior civil servant or public servant without repercussions, so how does that organization then have the moral ground to mete out sanctions to regulated entities when the same thing happens there? So that is why it is key for regulators to have internal effective E&C program. It is very key. You know, I see that in Nigeria today, there are no legislations that make it compulsory for government agencies and even companies to have E&C programs. So the purpose of this presentation is to sell to the regulators. And I hope that those of you who are who are attending this session will go back to your different agencies and let them see the reason. And I think that Mrs. Ososami, the moderator, will ask that question if you have time. How you can sell ethics and compliance to your management. We will get there. Now, you need to go back and say that, no, right now, the world is moving away from, in fact, there is the line between corporate governance and ethics has become blurred. People now concentrate more on ethics, doing the right thing. Whether you are a regulator, whether you are a company, do the right thing. So I don't want to go into the elements again. You know, you have the code of conduct, you have administration, compliance. Mr. Bamidele had spoken about all of these. So I do not want to go over them again. So let's move on to the next slide. Now, we are moving on to tools to ensure compliance by regulated entities. Now, before we go into that, I am maybe during question and answer session, the audience, somebody from the audience will ask this question and may respond to this. Now, my experience with regulatory and law enforcement agencies is that in Nigeria is that enforcement actions tend to tilt towards sanctions and prosecution. Now, you know, the regulator or the law enforcement agency finds an infraction, they investigate, and they apply sanctions, you know, penalties, fines, referral to prosecution, or where the regulator has prosecutorial powers, the regulator prosecutes itself. Now, since the beginning of the 21st century, regulators have moved away from reactionary enforcement procedures to preventive enforcement mechanisms. You know, issues like sanctions, prosecution of companies, they still do it, but it's no longer the focus of regulators around the world. Now, What I'm saying in essence is that now taking active steps to ensure that regulated entities have an effective internal ethics and compliance program, we ensure that regulators spend less time on enforcement actions. In fact, you will find that if you encourage your regulated entities to have effective ethics and compliance program, it is going to reduce your enforcement costs and indeed the compliance cost for the regulated entities. And what you are going to have is that it will boost public confidence and as well as investor confidence. Now, I'll give an example. For instance, in the US, they have what the Justice Department have what they call Principles of Federal Prosecution of Business Organizations. Now, what that is contained in the Justice Manual. Now, what that does is that it describes factors that prosecutors should consider in conducting an investigation of a company, whether they are determining to bring in the determination of charges, in negotiating plea and other agreements. Now, one of the factors is that the prosecutor, before he brings a charge against a company, is required to assess the adequacy and effectiveness of the company's compliance program at the time of the offense and the effectiveness of the company's compliance program at the time the decision to charge is made. Now, typically the manual asks the prosecutor, so what that does is that if, for instance, a regulated entity is reported and an infraction is reported, then as part of the investigation, the prosecutor must first assess the effectiveness of that company's ethics and compliance program before making the decision, do I charge? Do I ask them to implement remedial measures? What do I do? Now, the manual requires the prosecutor to ask 3 questions. Now, it says, is the company's compliance program well designed? Is it well designed? The second question, is the company's compliance program applied earnestly and in good faith? As a corollary to that, is the program adequately resourced and empowered to function effectively? What that means is that the prosecutor is looking at whether the ethics and compliance program is just a paper tiger. Nobody respects it. Sometimes you have some companies that when you ask them, well, where is your business ethics code for contractors? They just whip up a piece of paper or they refer you to something on their website. So that does not convince a DOJ prosecutor. He wants to know, is it applied in good faith? Is it applied earnestly? Does it bind both the management and the lowest employee in the organization? And is it adequately resourced? So who is the compliance officer? Is the compliance officer, for instance, in government agencies, if you have a compliance, if you have a chief compliance officer who is probably a level 7 civil servant, how do you expect that to function? Or who has to report to, who has very high hierarchy? It's not going to work. Now, so the third question, so does the organization's compliance program work in practice? These are the questions that the DOJ requires every prosecutor must to ask before charging an organization. Now, let's move on to what compliance tools are available to regulators in lieu of sanctions and of prosecution. Now, if I have a list on this slide, now the list is not exhaustive. It is merely a guide. You see, the list covers tools that some Nigerian regulators currently use informally or sometimes formally, and some are from outside Nigeria. So they do not provide, the list is not exhaustive. Let's take the first one. And then we try to look at the effectiveness and the weakness of each of them. Now let's take the first one. Now the first one is undertaking. Can you take the slide back? The first one is undertaking. Now, this sounds like a very serious tool, but it is not really that serious. It's a typical tool employed by law enforcement agencies. Sometimes the EFCC does it. The police also do this. Now, so when a matter is reported to a law enforcement agency, and it has to do with money, maybe a recovery of money, and the EFCC sometimes consider that if we decide to charge immediately, particularly where the two parties are companies, and if they charge the company or the directors to court, it may affect the continued sustainability of that company. So they will say, okay, fine. You, the suspect company, enter into, give an undertaking that you will repay this money that is the subject of this report over a period of time. And then really the suspect simply signs the undertaking and say, oh, I will pay. You see, and sometimes it could be, I was involved in a matter where the undertaking had actually been signed before the matter was reported to the EFCC. So what the EFCC just did was to say, well, we would hold you to this undertaking since you had already done this. So the challenge with undertaking as a tool for ensuring compliance is that it is not enforceable. It is not enforceable. It means nothing. And so typically what happens is that when there is default, the EFCC then brings a charge, or the law enforcement then brings a charge against the suspect. But at that time, it may be too late. For instance, I have a matter where something of this nature happened, and it took several years, and then this person, they gave an undertaking, they were paying and running into the amount of money involved is several millions of euros. And this suspect company was paying the money in ridiculous amount of money in naira, and we kept trying to put pressure on the EFCC to say these guys are not serious. Investigate, let us know whether a crime was committed. No, the EFCC said, "Oh, don't worry, we'll try." It turned out that while we, the EFCC, and us and our client were trying to act in good faith, this suspect company had a different agenda. Before we say Jack Robinson, they've gone to court, brought an action for fundamental human rights against the EFCC and the creditors, and now we are stuck. So that is so it is usually not enforceable, and you would find that even when the regulator tries to enforce it, the suspect or the entity that has signed this undertaking will simply just say it was signed under duress. So that's why it is not an effective tool to ensure compliance. We'll move on to the next one, plea bargaining. Please, not the next slide, the next one. We'll move on to the next one, plea bargaining. Now, plea bargaining, and I'm sure my colleagues on the law enforcement agents on our in the audience know this very well. Now, Plea bargaining is codified in the Administration of Criminal Justice Act 2015, and of course also in the ACJL of Lagos. Now, it is a tool of criminal justice, but it can also be used as a compliance tool by regulators. Now, and I will tell you an example of how it can be used. Now, for instance, where the infraction of a regulated entity rises to the level of a crime, the regulator and the prosecution may offer that regulated entity to say, well, put in place remedial actions, which can include adopting an ethics and compliance program designed by the regulator as consideration for reducing the gravity of the offense charged. So you say, well, now what you have done, this insider trading for SEC is a serious issue, you know, but your company is one of the companies Nigerians look up to. We know that you have employed 800 employees, 180 employees, 80 Nigerians are employed in your company, whatever number. So we don't want to kill you. But this insider trading is a serious issue. So what we are going to do is this. We are going to design an ethics and compliance program for you that you must abide by. So in lieu of charging you for insider trading, we arrange with the prosecutor to give you a lesser offense, but you must put in place these remedial measures approved by us. So that's one way plea bargaining can be used as a compliance tool. But the limitation of plea bargaining in Nigeria, as a compliance tool, is that it takes place after the defendant has been charged. This is different from the US. A prosecutor can do this plea bargaining before going to court, before charging the defendant. But in Nigeria, the defendant must have been charged. Or you could have the discussions before, but that is not the law. That is that's the regulator, or you could have it. But you must then charge the defendant before you can then present the plea bargaining agreement to the judge. Perhaps the final drawback of this, or plea bargaining as a compliance tool, is that it has to be approved by the judge or the magistrate. But in practice, there are so many instances where judges have refused approving plea bargaining agreements. So these are the limitations of plea bargaining as a compliance tool. Now the next one is settlement agreements. Now this is used by regulators across the world. You know, where you say, around the world, where you say, okay, regulated entity, come. We have found this infraction. You have done this, but we do not want to kill you. We want your business to continue. Now, here are the things we want. So you call the regulated entity to a round table. You decide, the regulator tells the regulated entity, this is what we want you to implement. And then the regulator says, oh, I can do this. They negotiate. Then they come to a settlement agreement. Again, a very good thing to do, but there is no legislation backing that up in Nigeria. We'll get to that in a minute. Now, the next one is deferred prosecution agreement. Now, this does not exist at all in Nigeria. And in fact, it is a tool, a compliance tool used in the UK. I think it was introduced by the Crown and Courts Act of 2013 in the UK. Now, it is an agreement between an organization and the prosecutor by which a potential criminal charge against that organization is automatically stayed. And the organization agrees that for certain requirements to be imposed, e.g. implementation of the compliance program, payment of compensation, etc. The advantage of a DPA is that it reduces the time and costs to be incurred by the regulator or the prosecutor in investigating and prosecuting infractions. And for the organization itself, what it does is that the organization avoids lengthy period of investigation, court process, and that may have lasting effect on shareholders and employees. And finally, on this slide, I also mentioned independent monitoring. And I know this is something that Mr. Soya would be very, very, very familiar with, because really is a tool that is used in contractor suspension and debarment. And I would like him, if you ask, during the question and answer, if you can shed more light on this. Now, what does this do? What this does is that the regulator and the regulated entity come together. The regulator identifies the problems. The regulator says, oh, I accept. I will implement A, B, C, D, E, F. For regulator, I do not want your officers to monitor this agreement because I'm always afraid of them. And because your officers are your employees, they will be biased. So let us look for an independent monitor to assess my compliance with this agreement. So typically, an independent monitor can be a very experienced compliance professional, could be depending on the subject of the subject of the matter. It could be a certified public accountant, just somebody who has sufficient experience and of course, it must be independent, very independent. So it must be somebody who has the trust of the regulator and the trust of the regulated entity. So let's move on to the next slide. Now, the way forward. You know, I assume that some members of the audience are thinking that this man, you are in Nigeria. Why are you telling us these things as if you are not in Nigeria? Yes, I am a Nigerian. And particularly for those of us who are lawyers, we may be thinking in our minds that, okay, so how can these things be implemented in Nigeria? There is no enabling law for this. So what do? You know, apart from plea bargaining, there is no legislation backing up most of these things. So what can be done? Now, as I said before, a well-formulated enforcement strategy includes encouraging regulated entities to adopt effective ethics and compliance programs. Honestly, your work as regulators will be easier if the regulated entities have ethics and compliance programs that prevent ethical and legal breaches or that catch such breaches before they escalate. This would reduce enforcement costs, protect the public, protect the reputation of the organization as well. Now, as I stated earlier, legislations encouraging organizational ethics and compliance are not that many in Nigeria. So what can the regulators do to incorporate ethics and compliance in their enforcement mechanism? Number one, and I've done this, and I need you to go back and do this. Check your enabling act. Now, check your enabling act. You don't need to go far. There are so many, when I say enabling act, let me try and explain that for those who are non-lawyers. This means that the act, the law that established your organization. Then typically, the law establishing a government agency will give that government agency the right to make regulations. Typically. Now, if your enabling act empowers you to make regulations, then that means you can issue guidelines to say, these are the minimal standards that we expect, or minimal ethical standards that we expect from the entities that we regulate. Honestly, you will sleep better. Because if you have those standards and you communicate these standards to your regulated entities, you know, that the standards must be the standards we already, Mr. Sonya now has already identified. That is the way you can get any, whether it is internal to the regulator or to the regulatory entity, that is the way you can get effective compliance and ethics program. Now, let's say you check your enabling act, and there is no provision that enables the agency to issue regulations. So what do? It's simple. If you have enforcement powers, issue standards that clearly state that the effectiveness of a regulated entity's ethics and compliance programs is one of the factors that you would consider when weighing whether to apply sanctions or not. That way you will not be running against the law, even if you're saying, well, it's not compulsory. But I'm saying to myself that if you have, okay, we know we don't have the power under our law to make this regulation, but at least we have an enforcement power. So here is it. Companies that we regulate, these are the minimal expectations, our minimal expectations from you in terms of ethics and compliance. And then, secondly, after you have checked your enabling act and you see that you have the power, what do? You document. Because if you don't document, you document what you expect the regulatory entities to comply with. If you go to any website, any US agency website, you see all of this there, free downloads. So communicate it to them, educate them, document it, and choose the right approach or a combination of approaches. For instance, you can say, I do not want to get to, because I'm a regulator, I do not want to, and I do not have prosecutorial powers like the EFCC or some other agencies. And really, I do not really want to invite the EFCC all the time there is an infraction. So what I need to do is to say, okay, I don't want to use plea bargaining. So we would rather use settlement agreements or something that is like a DPA. So you can just look at what works for your industry. And the last thing is that you test effectiveness. Mr. Soya spoke about this a lot. You know, there is no compliance program that can work if you don't benchmark, if you don't monitor, if you don't check every time whether it is actually achieving its goals. So that is all from me for now. Thank you for listening.
Thank you very much, Olukayode, for what I will describe as a very detailed and insightful presentation. Thank you, in fact, to both speakers. Before I move on to the Q&A session, I want to exercise my privilege as the moderator to chip in my own 2 cents on the subject matter for today. And bringing us back to the focus of today's session, which is essentially how to improve strategies to drive compliance. And I don't think the conversation will be complete if we do not also consider factors that could be responsible for non-compliance among targeted, the regulated entities. You know, the OECD published a report in the year 2000 on challenges for regulatory compliance. That report highlighted 3 common causes of compliance failures, some of which both of you have alluded to directly or indirectly in the course of your presentation. But I want to bring to light those 3 main causes. This is based on research from practices from various jurisdictions. And the 3 causes for compliance failures were identified as 1, non-compliance related to lack of regulatory knowledge or comprehension by the target group. Essentially, this is where people simply can't comply because they don't understand the regulations. It's too cryptic. They don't understand the requirements to comply with those regulations, sometimes because it's just too complex. The second cause is related to the willingness of the target group to comply with the rules. Willingness in the sense that sometimes when the cost of compliance is too high, organizations just generally look for how not to comply. Or when a regulation is perceived as unreasonable in terms of the timeline. So for instance, a regulation is issued and targeted entities are given 3 months to comply, and yet you need to put together certain kind of infrastructure internally to be able to comply. The third reason, as the OECD highlighted, is non-compliance related to the ability of the target group to comply with the rules. And this can sometimes happen where there's a lack of administrative capacity or where compliance is impractical. So bringing this to bear to today's discussion, I would like both of you to comment on these causes for non-compliance and to also offer the regulators ideas on how they can best deal with non-compliance based on these factors. In 1 minute each, please.
I think that's a great question, Lolade, and it speaks to the real issue, right? How can we overcome now? These challenges are real, and in Coyote's and my presentation, indirectly we answered that question. But you're right; those challenges need to be considered, and in looking at those challenges, it has to go back to the policy itself, right? And it also goes to the point Coyote made, and which I made as well, about monitoring, right? So we need to look at what is the challenges when we monitor. So it's not just a question of enforcement, because we're so geared or wired about enforcement. But Coyote said the cost of enforcement is huge, right? So make those challenges, we need to monitor and then see whether we need to make changes or we need to do a lot more on education and spreading the news to address understanding. You're right. Regulations are sometimes so complex because the people who make them are not necessarily the practitioners, the entities, the regulated entities. And therefore, this monitoring will allow us to understand what are those challenges. Is it because of the ability to comply? Is it because of lack of knowledge? Is it because, it's easier to not comply? There's no willingness to comply because, it's too unwieldy. How do we know this? We can only know this if we monitor what are the reasons why there is a lack of compliance. So it's interlinked. We find out the solution by conducting and monitoring a test to see why people don't comply. And, I hope with that, we can address those challenges.
Thank you very much.
Thank you.
Elukade, your thoughts? Please unmute.
I absolutely agree with Mr. Soya. We touched on those issues. So at risk of repeating what Mr. Soya just said, less focus on enforcement, more focus on engagement. So that's all I have to say on that issue.
All right, thank you. We're still continuing the conversation. As we move on to the Q&A sessions, I have a list of questions here that I will direct to each one of you, and I may call on specific persons to answer each question, and where I don't, I may also ask for comments from both. So, Bami, this goes to you. Based on your experience, what are the typical issues and challenges that impact the effectiveness of an ethics and compliance program, either positively or negatively? Please unmute.
Thank you very much, Duade. This is also an important question that, some of the messages we have shared this afternoon. In terms of positively, like I said before, if I were to choose one thing that makes a lot of difference, it's the behavior of the leaders themselves, right? So in this context, how does the regulated entity view the regulator? Do they have our interest at heart? Are they also living by the same standard they expect us to live by? This is the same way in a corporation, whether a public body, whether it's a company. The question is, what example is the leadership setting? That is fundamental. That creates a positive vibe. Whether it's a regulated entity, whether it's the regulator, it creates a positive vibe when the leaders, but then let's not take it for granted. Do they understand? And I think Carl was making that point. Do they understand the importance of ethics? Do they understand the importance of an effective ethics and compliance program? I think I saw some of those questions there. How do I convince? I'm not jumping the gun, but it's interlinked. There's a benefit to it. You are in compliance with the law. You protect your reputation. It goes to the sustainability. Carl was mentioning, a company may die, right, if it doesn't follow the rules. So it goes to sustainability. And those are the positives in terms of how do you positively impact compliance. The tone at the top is key. You have policies in place to ensure compliance. Now, if you reverse it in terms of the negative, if there's a lack of internal justice, now what do I mean by that? If there's a perception that these rules don't apply to us, the rule maker, it undercuts the message, completely undercuts the message. If the enforcer is not living by the same standard, if the leadership is not living by the same standard, it undercuts the message of compliance. And so, these are the issues that affect the effectiveness. Thank you.
Thanks. We seem to have quite a few questions on this issue of ethics, having an ethics and compliance program. The next question is from someone who works for a regulator. And the person says, as I work for a regulator and an ethics and compliance program does not yet exist in our organization, how do I convince my management to put in place an ethics and compliance program? I think there's a lot of things that have been said this afternoon that should convince those in leadership roles within regulatory agencies who are attending this webinar, for instance, to begin to see the need to have an ethics and compliance program, even within the regulatory agencies themselves, because this helps to create the mindset to set that tone at the top that you have touched on severally this afternoon. Olukayode, I would direct this question to you. Please provide your views and thoughts on whistleblowing as an effective tool to achieve compliance. Please unmute.
All right, so if you go back to the slide on elements of effective compliance, now, one of the elements of having an effective ethics and compliance program is reporting and investigation. Now, that reporting means that your ethics and compliance program must provide for a reporting system, which just means whistleblowers, essentially. It must provide for a reporting system by which employees, staff members can anonymously report misconduct. Because without giving that opportunity, the management or the oversight authority will never know that an infraction has been committed. So whistleblowing is an integral part of compliance. You cannot have an effective compliance without it. Now, as a corollary to whistleblowing, you must also ensure that there is no retaliation, because it's all together. So you have a whistleblowing system. You must ensure that if the whistleblower wishes to remain anonymous, they can remain anonymous. Then if their identity is disclosed, you must ensure that there is no retaliation against them. And then every whistleblower's complaint, regardless of how frivolous it may be, should at least receive a measure of attention, whether pre-investigation or full-blown investigation, depending on how your preliminary assessment, what it shows, whether it is just one of those reports or whether it is a serious infraction. So I cannot overstate the importance of whistleblowing to effective ethics and compliance program.
If I may just add quickly to what Mr. Olukade said, just to underscore the importance of the whistleblower protocol. In the US, you have companies that provide, to make it, just to elevate it so that you can appreciate the importance of this whistleblowing protocol. You have independent organizations who provide the reporting, anonymous reporting services. So for example, at the World Bank, just to make sure that a whistleblower feels comfortable and confident to use it, it is not, in addition to reporting by emailing to us directly, that's the World Bank Group or IFC, we also have a third-party company, I think it's Navex, right? I'm sure Kaude may be familiar with them. Navex runs, this is a very big ethics company, ethics and compliance. They provide database and all, but they also run a hotline so that somebody can contact this independently of the World Bank to make a report. And guess what? You can make those reports in over 100 languages. This is how important these services are, I should mention.
Apologies, I was on mute. Thanks, Bami. That's very useful to know. I have a question here directed at Olukade. Olukade, you spoke about effectiveness of undertaking. Ms. Honora would like to know, she says, in my organization, we sometimes ask clients to give us a letter of undertaking. At times, we request that the letter be notarized in the court to make it kind of legal. In times past, we had also gone into signing of bonds with companies involving financial deposits that could be lost. How effective do you consider these?
Okay. Ms. Odiora, honestly, undertakings are effective if they are signed in the context of a contract. So I think what you have described is an undertaking in the context of a contract, like a bond, or if somebody has an obligation to you and undertakes that I will, in the context of a contract, an undertaking is effective. But I spoke of undertaking in the context of law enforcement, where a person has been arrested and the reported allegation has to do with money. And then the law enforcement agency has now said, okay, we don't want to charge you, give an undertaking that you will pay this money back. So there are two ways to that. The man is going to say he's in a police station or is in the EFCC office and he wants to go home. And the IPO or the investigating team has asked him, well, we will not detain you. Enter an undertaking now, you will pay the money back. The man is going to go to court and say it was under duress. So he's not going to honor it. Perhaps if he honors it to some point, he will say, and then he decides to breach undertaking, he will go to court and fight for the mental rights. And you cannot enforce that undertaking against him. So that one is different from a contractual undertaking, where somebody wants an obligation from you, owes you an obligation, you say, give me an undertaking signed by you. That, of course, is binding. But that is not a criminal matter. That is a civil matter. And in the event of breach, you will have to enforce that in the civil court.
I hope that answers your question adequately, Ms. Honora. Just to also mention that we do provide those services in our firm. The next question is from Mr. Lawrence Umana, and I will direct this to Bami. Mr. Umana says, what do you do to ensure tone at the top? What do you do to ensure tone at the top management where you discover lack of a buy-in by a top management?
You know, there are various ways. I think that's a great question. You know, I took up my position with IFC, having been in Nairobi. In Nairobi, it was very, very easy for me because in the Africa region, I had the buy-in from our country director. So it was easy. My job there was very successful, and this has led to the creation of additional offices, like I was mentioning earlier on, in Senegal and in South Africa, because of the buy-in from the Africa region World Bank Group management. Now, I have a new position as ethics officer for International Finance Corporation. And I'm trying to, so this is a question that's very practical for me. You know, the reason why we created the position that I'm occupying right now is because there has been no enthusiasm. Let me put it, let me not use buying. There has been no enthusiasm from leadership in the, you know, in IFC, like the World Bank. You know, this is relative. So what am I doing to ensure buying? Is to being there at the right moments. What do I mean by that? There's a code red. You know, I like to use the language of Robert Chestnut. There's a guy that I admire very much. He was formerly general counsel at Airbnb. He's now, he's still there. He used to be chief ethics officer. So I like to use some of his language a lot. I like the way he has handled ethics at Airbnb. He uses the word code red. So there's a code red moment that you have to identify. Let me give you a practical example. Right now, with the racial justice issues in the US, against, you know, racial discrimination, with the pandemic, this is a code red moment for most organizations. There's a willingness, therefore, to talk about ethics. So right now, I'm in the middle of a drive to train over 1,000 new staff who joined IFC since January of this year. They are working from home because of pandemic. So they are disconnected from the culture of the IFC because they're working in various countries all over the world. Now, I was able to sell this to them without much, you know. So management, you got to identify code red and code blue moments where you can support and convince management. You know, ethics is not sexy. I like to say that. It's not a sexy topic. But it's a topic that is essential, and you can demonstrate it by using those code red moments when things go wrong. When things go wrong, to convince management of the importance of the ethics agenda. I'm using that right now. I'm getting a lot of buy-in from management because things are challenging now. I help them with framing their language in terms of responding to the general staff about the issues going on now. So it is challenging, I have to recognize that, but you have to be able to demonstrate, you know, there's a cost to reputation of the organization, there's a cost in terms of money as well. And these are the things that we use to get the buy-in from management. I hope that helps to answer your question.
Thank you very much, Mr. Sonya. More questions are coming in. I will direct this to Olukayode. The SEC Nigeria has provisions in its rules and regulations on negotiated settlement, even when a matter has been instituted in court. But there are certain violations that cannot be settled via negotiated settlement. I think this person wants you to comment on this. Olukayode, can you comment on that statement? Please unmute.
Sorry, I was muted. And that's actually correct. Rule 600 of the SEC rules and regulations provides for negotiated settlement, you know, between the SEC and the regulated entities. But I do not have the rules here right now. You know, I do not have the rules here right now. Now, the question is, The question is whether no one has tested the effectiveness of that, but it's good that the participant mentioned that. Yes.
Yes. I also have a question here from Afolabi Adiremi, and I would like both of you to answer this, starting with you, Olukayode. How do we mitigate the use of human rights protection to scuttle criminality?
Well, I assume that the question was asked by somebody, one of our friends from one of the law enforcement agencies. It is, I'm not surprised that that question is asked. It's a question that we get asked every day by our friends on that side. Now, I actually don't, I will just say what Nigerian law is. Now, the other Nigerian law, there is nothing that stops a civil and a criminal matter from proceeding concurrently. Now, the fact that a civil action has been instituted does not stop the law enforcement agency from bringing a criminal charge, provided that the criminal charge is not in bad faith or as a reaction to the civil suit instituted by the suspect being investigated. So that's Nigerian law. So what then happens in practice, again, depends on the understanding of the investigating team, the legal team of the agency, and what's not. So that is the position of the law.
Okay. Bami, what's your response to that question? Thanks, Olukayode.
My response to that question is that we are very fortunate under our own legal regime. You cannot challenge, you cannot bring an application. People have tried it, but you cannot succeed in our application to challenge our jurisdiction to go through our sanctions process by bringing a fundamental human rights challenge at the court. We are protected because of our privileges and immunities, but I can see how this can be a hindrance, especially in a legal system such as Nigeria and in most of the developing countries where proceedings take for so long. People can bring any frivolous application and delay the justice process, right? But I think to the point that Olukayode was making, the fact that you have brought that allegation, that challenge, does not negate the civil proceeding that is going on side by side. But in terms of the practicality, we have had situations at the World Bank Group where our sanctions process has been the subject of litigation, where somebody has brought an application that they have not been accorded due process, right? And we have pleaded our privileges and immunities to scupper that challenge.
Interesting. Thank you very much. May I just say, if you have questions, kindly post your questions in the Q&A box and not in the chat box, because we can't have both boxes open at the same time, and the focus at the moment is on the Q&A box. So please, if you want your questions answered, kindly post them. You can just cut and paste into the Q&A box. Thank you. I have a question from someone at EFCC who has said, this topic has been well presented. Thank you. I must say the presentation is very instructive. My concerns are that the presentations have not taken the peculiarities in Nigeria into context. Regulators and operators in Nigeria deliberately compromise regulatory measures under the guise of esprit de corps. There has been a situation I'm very familiar with where a regulator refused to impose administrative sanctions against an entity on the grounds that such imposition of sanctions will affect the business integrity of that institution. The question is, how do we deal with this kind of mindset of our regulators? I direct that question once again to both of you, and I'll have Olukayode go first.
Okay, so it's an interesting question. Again, it comes down to ethics and compliance program. You see, if that regulator, has an effective ethics and compliance program, one person, regardless of his position in that regulator, will not make that kind of a decision. So, and that is why that is the essence of this training. Because if the organization and I don't know that organization, that regulator, if the regulator has an effective extra compliance program, you have had a policy that clearly provides for when you apply administrative sanctions. So, and whoever is in that place who decides that, well, it doesn't matter, business integrity, that is it. You cannot leave decisions like that to the whim and caprice of one civil servant. I'm sorry to say. It has to be, you must have a policy that says, how do we make these decisions? At what level? Which committee? That is the essence of this presentation. And honestly, that regulator should come to us. We are willing to help them design an effective ethics compliance program. And such a thing will not happen again. In case you know them, my friend.
I'm really gearing to respond to this question. So, me, I have practiced law in Nigeria. I practice law all over the United Kingdom. And I now work at the World Bank, right? So when you use the phrase, the question was talking about the peculiar environment, right? That's what it alludes to, that Nigeria is a peculiar environment. My experience does not necessarily support what you have just said, that every place has its own peculiar environment. You want to ask me about some of the things I've seen at the World Bank, you'll be shocked, right? So let's not put that in. Let's say that your question relates essentially, as Oluka said, this is why an ethics program is needed. You create an environment where it is not comfortable to do what is wrong. That is what we're talking about. Every organization, whether a regulator, an entity, they are where they are. We want to move the needle forward. And how do we move the needle forward? We make the environment uncomfortable to do the wrong thing. And that's what the culture, that's when we talk about, this is about changing culture, right? So I'm not saying there's no peculiarity in your environment. There is peculiarity in every environment. But when you have an effective ethics program, little by little, it moves the needle forward. That is the reason, that is the purport of this session. Thank you.
Thank you very much. Thank you very much indeed. I have a question here from Mr. Usman Tuko. He says, what would you consider a better model to run a whistleblowing program from a special office under the chief executive? I'll read that again. What would you consider a better model to run a whistleblowing program? From a special office under the chief executive or as part of the investigations department? Before you answer that question, I'd also like to add Mr. Ahmed Sonny's question, who has asked, as a follow-up question to the whistleblowing practice and as a way of encouraging the practice in the workplace, do you think companies should engage in giving incentive or rewards to encourage intending whistleblowers? So, Bami, I'll have you answer the second one, and I'll have Olukade answer the first part. Olukade, do you want me to repeat the first question or you're with it? Please
ask the question again, sorry.
What would you consider a better model to run a whistleblowing program? Is it from a special office under the chief executive or as part of the investigations department?
Okay, so let me just put it this way. It is very important. Effective compliance, ethical compliance program usually requires that the compliance function be independent of the chief executive. That is usually the best practice. And that is why I saw a question in the Q&A box where somebody asked whether you should separate that function from the legal function. Absolutely. They are not the same. So they're not the same. The legal function is one of the compliance function, even though they say lawyers make best compliance officers. But the truth, I think that the whistleblowing system should be as between being situated under the chief executive or in the investigations office. It is better to be in the investigations office, where I assume the compliance function resides. Because the reason for that is clear. What if the reported infraction is against the chief executive? How do you maintain independence? And this question, again, has brought to the fore the argument as to whether the whistleblowing system should be domiciled within the organization or should be domiciled with an independent third party. And Mr. Sawyer mentioned NABEX the other time. No, our firm also provides that service. So I should mention Mr. Sawyer because you mentioned NABEX. We also add that service. Now, so you can domicile it outside so that when the complaint comes, you have independent experts that assess this complaint and confidentially transmit it to an identified function within the organization. So you would have, so if the report is concerning the chief executive, they know how to handle it, where it will go to. Because there's no point, for lawyers, it says you cannot be a judge in your own cause. So domiciling a whistleblowing system under the executive is a no-no when it comes to compliance. No.
Thank you very much, Olukade. We're pressed for time, but I think you've made the point very strongly there. I'll just have Bami comment very quickly about the issue of incentives, giving incentives or rewards to encourage intending whistleblowers.
Thank you very much. Kaude, let me just comment briefly. Kaude made a powerful response, which I really completely agree with on that first question. In terms of rewarding whistleblower, this is something that is done. We don't do that at the World Bank, but I know that in the US regulators, they do that. In fact, they give you a percentage. So for some things like money laundering and some financial crimes, you actually get and Kaude will know this as well, you actually get a windfall. You get a percentage of what is recovered in terms of, when you make those reports. So this is a way to encourage whistleblowing. Now, as an organization, we don't do that. We don't reward people who make a report, but it's an incentive structure to get people to make reports, and this is widespread in the US.
Thank you very much. I have two more questions here. I won't be able to take all the questions, unfortunately, but I will take these two. One is from Tosin Olaiwola. He says, where an individual takes advantage of a loophole in the code set by an organization, who bears the risk, especially where such is deemed to be criminal in nature? Olukade, do you want to comment on that? Please unmute.
Ms. Osabi, I must apologize. I didn't hear the question, sorry.
Where an individual takes advantage of a loophole in the code set by an organization, who bears the risk, especially where such is deemed to be criminal in nature?
Well, if anyone takes advantage of a loophole,
yes, in the code.
In the code.
Please answer in 60 seconds.
Okay, so I think that there is no direct answer to that question. Let me put it this way, because it depends on the cadre that person belongs to, and whether that person has real or ostensible authority to bind the organization. So, for instance, and this Lagos State criminal law has a very fine provision on this issue as to when the action of an employee will bind the organization. So if this person is a director and the act is done on behalf of the organization, there is more likelihood that action will bind the organization. But if this person is a junior employee who decides to go on a frolic of his own, the employer cannot be bound by that action. Except, of course, the law says that, when the employer discovers the infraction, he does not take any steps to prevent the continuous perpetration. So I hope that answers the question.
I believe so. Thank you very much indeed. The last question now goes to you, Bami. How do you balance encouragement for compliance and punishment for non-compliance in an organization?
Thank you very much. I think this thread runs through all the presentation. There's no doubt I think we are all convinced that you need to have enforcement, right? But that should not be the focus. Unfortunately, it is being the focus for so long. So it's very habitual. It's what we do all the time. But the trend now and the science, and I keep saying that because we focus on the science at the World Bank. We bring in people to come and tell us what their research. There's a lot of research out there, and so we encourage that discussion. Academic, it might seem, but it's very pertinent. And so we focus more on ensuring people understand why they need to comply rather than the enforcement. And I think over and over again, Kaude has been talking about the cost. It's not just in Nigeria, but in every jurisdiction. The cost of enforcement is a lot. And therefore, we concentrate our efforts on making sure that people understand the policy reason behind those regulations and why, and we will encourage them. We will set up a program. We will support them. I think that's what the regulation should be thinking about. At the World Bank, when there's an infraction, we don't necessarily just debar companies. Some of the tools that we use is helping them to build a compliance infrastructure. And I think our regulators in Nigeria can also begin to think about this, that is cheaper. You have independent monitoring. I think I already mentioned that as well. Some of them, we help them. We don't choose for them, but we look at the CVs of the independent monitor to look at that these are professionals, ethics and compliance professionals, to help them with putting that right infrastructure in place. And we will give a pass. If a company is a first offender, we'll give a pass in terms of disciplinary measure. We'll help them with putting that infrastructure in place instead of punishing them. So this is the trend, not just at the World Bank, but globally. And I think the earlier the Nigerian regulators embraced that, the better for the enforcement regulation generally. I think it's key. Yeah.
Thank you so very much. Ladies and gentlemen, participants, I'm sure that you have listened with very keen interest. The conversation continues. But as we bring this masterclass to a close, we would like to thank you all. And we extend our gratitude, especially to the leadership of all the regulatory agencies represented on this webinar. We at UUBO remain committed to providing support through knowledge sharing and capacity building initiatives. And of course, we'll be happy to support on an advisory basis as well. We look forward to your participation in our future events. Thank you very much indeed. Have a nice evening. Goodbye.